Your Honor.
Patty, did you holler?
Yes, I mean, I was just telling him we were ready.
Okay, I'll let him know.
Okay,
Ready on the second.
John Piercefield, come on down.
This is cause number CR 22-75, State of Texas versus John Daniel Piercefield for docket call. Mr. Schmidt, as you're aware, Mr. Bill Stevens has been appointed to represent Mr. Piercefield. Mr. Stevens had indicated he was unable to be at court today. I think he's got some medical issues going on with his wife, not certain. So in the interest of justice and for Mr. Piercefield's rights, the court is removing Mr. Stevens and is appointing you as counsel for Mr. Piercefield. I do have a note here that Mr. Piercefield has been in custody 93 days, just information for you. And so obviously you've been appointed today. I know you're not ready for docket call. Unless there's any other announcement, then you want to reset, then we can just go ahead and reset.
Yeah, Judge, I briefly discussed the case with Mr. Piercefield and the status. I informed him, the consequences of me taking over, and we'll try to fast track and get it. In other words, we're going to do everything we can to prevent any further delay. As soon as I get the evidence from the DA's office, we'll get together and review that. But I guess at this point, what I would ask is just carry it over to another docket call and ask leave of the court to file any late pretrial motions if my review of the evidence determines that I need to do so, rather than setting it for another pretrial session.
Yes, sir. That'll be granted. Court will set Mr. Piercefield. I know it's not a whole lot of time, but let's set him for February 18th. And then if you're not ready, you can just tell me you're not ready. But let's go ahead and set him for February 18th at 1:30 for docket call.
Ms. Dallas Hightower.
Dallas Justin Hightower, CR 23-217. Is Mr. Hightower doing a plea today?
That's correct, Judge.
All right, Mr. Hightower, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you, sir. You can lower your hand. All right, Mr. Hightower, you're here on the state's motion to adjudicate. And prior to that, you were in this court on February 27th of 2024. You pled guilty to the offense of indecency with a child by exposure, a third-degree felony. After hearing the evidence, the court found that there was enough evidence to convict you, but it did not convict you on that day. The court deferred a finding of guilt, placed you on community supervision for a period of 5 years, and also assessed a $1,500 fine. It appears that during your period of supervision, the state of Texas filed not one, not two, but actually 3 motions to adjudicate, the last one being the third amended motion to adjudicate. And in that motion, the state has alleged 7 allegations and separate counts of violations. Have you had enough time to review that motion with your attorney, Mr. Schmidt?
Yes.
And do you understand everything that you have read and signed today that's part of your plea agreement?
Yes.
Are you happy with Mr. Schmidt and the work that he's done for you as your attorney?
Yes.
Mr. Schmidt, do you believe Mr. Hightower is competent today to enter into an agreement, and that if he does so, that he's doing it intentionally, knowingly, and voluntarily?
I do to both questions.
And does he waive the formal reading of the third amended motion to adjudicate?
Yes, sir. We'll wait formal reading and intend to enter a plea of true law, all counts.
All right. All right, Mr. Hightower. As to counts 1 through 7 in the state's third motion to adjudicate, how do you plead to those counts? Are those counts true or not true?
True.
You pleading true to each one of those counts because what is alleged in there is in fact true?
Yes, sir.
Has anybody threatened, forced, or pressured you to plead true to any count today?
No, sir.
All right. Court will accept the defendant's plea of true to each count as alleged and will take judicial notice of the defendant's judicial confession. Court finds that there is a plea agreement in this case. Upon that plea of true, the state's recommended that the defendant's guilt be adjudicated, that he be convicted of the offense, and that his community supervision be revoked. And the recommendation is 6 years confinement in prison, along with a balance of his financial obligations, including a $1,500 fine, $290 court costs, and $85 in reimbursement fees, and him receiving 112 days credit towards his sentence for the time that he's already spent in jail on this cause. The court hereby follows the plea agreement and recommendation, convicts Dallas Justin Hightower of indecency with a child by exposure, a third-degree felony. Court follows the plea agreement as previously stated. Mr. Hightower, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Court does find you guilty of the third-degree felony offense of indecency with a child by exposure, finds that this is a Chapter 62 offense. Has Mr. Hightower been provided? I believe he was probably provided with a copy of Chapter 62 at the underlying.
He was, Judge, yes, and we executed the supplemental admonishments at the time of the underlying plea.
Okay. All right, Mr. Hightower, when you're released from prison, if you've not paid off your fines and court costs, you'll need to report to the Van Zandt County Courthouse to make arrangements. You're not going to be able to sit those out in prison. They don't discharge them once you do your sentence. So when you get out, if you'll contact the courthouse and talk to the district clerk, they can make a payment plan for you, okay?
Sure.
All right, step over to be fingerprinted. Who's next?
That's all I have, Judge.
That's all you have, Mr. Schmidt?
Yes, sir. Mr. Manning's working on paperwork, so he should be ready in just a second. Yes, sir.
All right. Mr. Manning, who are you ready on?
Judge, this is Miss Miller. She was reset from Tuesday. She explained to me that she wanted to take the state's offer for state jail.
All right. This is cause number CR 24-279, State of Texas versus Stacia Lee Miller. Ms. Miller, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I sure hope so.
What does that mean?
I'm just, yes, sir.
Yes,
Yes, sir. I'm sorry.
if you tell me you hope you're going to tell the truth, that gives me doubt on whether you're going to tell the truth.
I'm sorry. Yes, I'm going to tell the truth. I am an honest person.
All right, you can put your hand down. All right, your name is Stacia Lee Miller, correct?
Yes,
Miss Miller, are you a United States citizen who reads, writes, and speaks English?
yes,
Have you ever been diagnosed with a mental condition?
yes.
And what is your mental condition?
The latest and greatest is major depressive disorder, schizoaffective, and borderline personality disorder.
Are you currently on medication for those?
Yes, I am.
Do you feel like you have a rational understanding of what's going on here today?
Yes, I do.
All
Yes,
right.
sir.
Are you in any way being having difficulty understanding what's going on because of your mental conditions?
No,
Okay. In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done as your attorney?
yes, sir.
Do you understand everything he's explained to you?
Yes, for the most part.
Judge, she did have a question on the fine. When I was discussing the offer, either I failed to communicate to her that there would be a fine associated, or there wasn't a fine when it was discussed.
The fine was with a three-year TD, the other offer was 3 years TDCJ and with the fine, and then the state jail was just 1 year state jail. So I don't know how that works, but that's what I'm,
Okay. Hey, let him explain it to me.
yes, sir.
So, Ms. Miller would like the court to know that she is still indigent and homeless, and she's concerned that this financial burden on her once she gets out will just result in her being incarcerated again on the KPS Pro fine. I told her that we could ask the court to extend her finding of indigency, but that was not the agreement that we had reached with the state. And so she would just like the court to be made aware of her financial situation, her continued indigence. We asked the court to take judicial notice of her application that was filed as it's still in effect.
Okay. And do you have any other questions or confusion about anything, Ms. Miller, before we go forward?
No, sir.
Okay. Mr. Manning, do you believe Ms. Miller to be competent today?
Judge, given my limited interactions with her, I do believe she is competent. She did have some questions about some of the terms of the agreement that I was able to explain to her. And so I believe she does understand and is making her voluntary waivers of her rights to go in order to go forward with this plea.
All right, Ms. Miller, you are charged by indictment with a third-degree felony offense of prohibited substance or item in a correctional facility. However, I see that the plea agreement between you and the state's recommendation is for you to plead guilty to a lesser offense of possession of a controlled substance of penalty group 1 less than 1 gram. The recommendation is on punishment that upon your conviction, you be sentenced to 1 year confinement in the state jail division of TDC, along with a $750 fine and restitution of $180. In addition, you would be responsible for court costs of $290 and reimbursement fees of $20. And you would receive towards your sentence your time that you've already spent in jail on this case, which is 146 days. The range of punishment for a state jail felony is no less than 6 months in prison and no more than 2 years in prison, and a fine of no more than $10,000. So I see the plea agreement fits lawfully within the range of punishment. Understanding all of that, Ms. Miller, how do you plead to possession of a controlled substance of penalty group 1 less than 1 gram?
I plead guilty, sir.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anybody threatened, forced, or pressured you to plead guilty?
No,
All right, then the court does accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection is offered.
All right, the stipulation is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
Judge, just our previous statement on Ms. Miller's indigence and her continued indigence as she goes through state jail and exits state jail to be once again homeless.
Okay.
If it's like another month, can I get that too?
Judge, she's having a question on the back time credit. When I asked her if the back time credit was correct, she said yes, but she's now asking about some time prior to when she was picked up in Van Zandt County. If I can have just a moment.
Yes, sir, go ahead.
Look, just hold on. Thank you, Judge.
All right. So is that issue been resolved?
Judge, she was asking after this 146 days that she's been in jail, if she will continue getting credit while she's waiting to be picked up by state jail. I explained to her that once she pleads today, this back time credit is only for the days that she spent in custody up to this point. that all credit going forward will be kept track of by TDCJ, the State Jail Division, and that she will receive credit for each and every day that she's been in custody, whether here or in state jail.
That is correct. Thank you, Mr. Manning. Okay, if there's nothing further, then the court will review the evidence. I don't have the stipulation of evidence. Can you display it to me?
Yes, Judge.
Perfect, right there. All right, thank you, Mr. Manning. And can you confirm to the court that there was a positive lab test for a controlled substance?
I believe the state has that lab, but yes, I can confirm that I went over that lab and did test positive.
Could you confirm that for me, Mr. Hernandez?
Yes, sir, it was.
Okay, and was it what was the controlled substance?
Methamphetamine?
Okay, all right, thank you. All right, the court finding that there is sufficient evidence to convict the defendant, the court follows the plea agreement and recommendation of the state. Court hereby convicts Stacia Lee Miller of the lesser included offense of possession of a controlled substance in penalty group 1 less than 1 gram. The court assesses punishment at 1 year confinement in the Texas Department of Criminal Justice State Jail Division. Court assesses a fine in the amount of $750, restitution in the amount of $180, and court costs in the amount of $290, and reimbursement fees in the amount of $20. The court awards Ms. Miller 146 days towards her sentence for the time that she has spent in jail on this cause. As to credit towards the fine, Ms. Miller, I'm going to defer any kind of ruling on that at this time. Once you are released from TDC, I want you to come to the courthouse. I want you to make a payment plan. And if you stay clean and you show me that you're making an effort at staying clean and being a productive member of society, then I will consider waiving your fines and court costs in full later down the road. So I'm not going to waive your fine at this time, and I'm going to wait, and we're going to see how you're doing when you get released. Okay? All right. All right, Ms. Miller, you're hereby remanded to the custody of the custody of the sheriff so they can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. What do you want next, Mr. Manning?
Just we can do Mr. Let's see who's first on my list. We can do Mr. Cromwell.
This is cause number CR 24-309, State versus Phillips Shane Cromwell, set for arraignment. Go ahead, Mr. Manning.
Judge, if we may have the indictment displayed.
Okay, just one.
Judge, my client's name is spelled correctly. He understands the charge against him as well as the range of punishment. At this time, he's pleading not guilty and requests to be set on the pretrial docket.
All right, the court enters Mr. Cromwell's plea of not guilty into the record, finds that he's waived the formal requirements of arraignment. Court sets this matter for pretrial hearing. You want to set this one in March, Mr. Manning?
Yes, Judge.
We're going to set on the next evidentiary date, which is the only Thursday I have in March, which would be March 27th at 1:30.
Yes,
If
Judge.
Mr. Cromwell makes bail, his hearings will be at 9 a.m.
And Judge, in preparation for the next one, we'll also need the indictments on Mr. Danforth.
Thank you. Go ahead and have Mr. Danforth come on up. Do you need the indictments in each case?
Yes, Judge, if you don't mind. March. Judge, we actually have a copy of the assault, so if we can just have the possession, that's the only one we need to do.
Hang on, Mr.
Stage. Judge, Mr. Danforth's name is spelled correctly. He understands the charge against, or both charges against him, as well as the range of punishment, and asks that he be set on the pretrial docket.
All right, the court finding that Mr. Danforth, having waived the formal requirements of arraignment, enters his plea of not guilty on each case. Court sets each case for pretrial hearing. Do you want that March date?
Judge, I think we can do the February date on Mr. Danforth.
All right, we'll set them for February. I've either got the 13th or the 20th for you.
Judge, if we can do the 20th.
All right, court sets Mr. Danforth for pretrial hearing February 20th at 1:30. Who's next?
Judge, next ready on Mr. Hagen.
Jeffrey Ray Hagen, CR 22-180, motion to revoke. Go ahead, Mr.
Judge, if we can, we have not reached agreement on this case. If we can set him out for the next contested docket.
Court sets Mr. Hagen for contested hearing on February 20th at 1:30. If Mr. Hagen reaches an agreement, we'll take it up that day. If not, then we'll have a contested hearing on that day.
Yes, Judge.
Who's next, Mr. Manning?
Judge, do we have, I see it's 2 o'clock. Do we have Mr. Hubbard? From Henderson County?
I do have Henderson County logged in. I didn't know if that was for you or for Mr. Schmidt on Miss Wiggins, because he also has a plea from Henderson County.
Okay, I have Timothy Hubbard, a Zoom request from Henderson at 2 p.m.
Sure, let's see.
Ms. Abraham says that she thought Wiggins should be at 1:45.
Maybe, but it being 2 o'clock, I don't know how they've logged in. So all I can do is bring Henderson County in and see who it is. They don't list who it is, so. If I bring Henderson County in and it's Miss Wiggins, then I'm gonna have to bump you and then I'll bring Mr. Schmidt in.
That's fine, Judge.
Okay, here we go. And I do have Johnson County too, Miss Taberham. And Mr. McBride's here as well.
That's at 2:15.
Do we have someone from Kaufman also?
Judge, that's gonna be Mr. Phillips, the one we're gonna request a breakout session on.
Okay, I think we probably have that one too. It's logged in as Cisco, so I'm not sure if that's Kaufman County, but that is an unidentified person in the, or
Yeah, I don't show the video yet though. Hello?
Hello?
yes, is this,
I heard you looking for me. I thought.
who is this, Mr. Manning?
Yeah, I called Master with the
Judge, I believe this may be Mr. Hubbard, Timothy Hubbard.
Yes, it is.
All right, Mr. Hubbard, just bear with us while there you are. I see you now. That's you
Okay.
here. And can you stand up so we can see you?
Yes, sir.
There we go. Excellent. Can you see us?
Yes, sir.
All right. You see your attorney, Mr. Manning?
Yes.
Excellent. All right. Court's going to call your case, Mr. Hubbard. This is cause number CR 24-75, State of Texas versus Timothy Wade Hubbard. Mr. Hubbard is appearing from the Henderson County Justice System or Justice Center. And I believe, Mr. Manning, we are set today on docket call, I believe. Go ahead, Mr. Manning.
Judge, we're at rest for reset. Obviously, Mr. Hubbard is not in Van Zandt County for me to make final preparations for docket call. So if we can just reset his docket call until he completes his business down in Henderson County.
Do you know when that may be?
I do not, Judge.
I signed for 10 years, TDC, like 12 days ago or 13 days ago.
You said 2 years or 10 years?
10.
10, okay. Do
Yes,
you
sir.
know if you have any other charges pending out of Henderson County?
Oh, no, I'm waiting on chain, or I thought actually I was gonna go to Van Zandt County before I went to prison, but
Okay. All right, then, Mr. Manning, how about we set him for February 13th? Would that be enough time?
Yes, Judge, and if we can get a bench warrant on him, that'd be appreciated.
All right, court sets Mr. Hubbard then for docket call on February 13th. Mr. Hubbard, we will execute a bench warrant and have you brought to Van Zandt before you catch the chain to TDC so we can try to resolve your case here, okay?
all right, cool. So I'll be coming to Van Zandt before I go to TDC.
That is the plan, yes, sir. And
Thank you.
that is unless Henderson County's already got a TDC ticket for you and
I
TDC.
doubt it. I know people's been here for 4 or 5 months waiting on chain, and I just signed, just like I said, on the 8th of January.
Okay, we'll have a bench warrant over there within probably 48 hours. So we should have you over here before you go to TDC.
Okay. All right. Thank you.
All right, thank you, sir. Do appreciate you.
Thank you.
I'm just gonna leave Henderson County in so we don't have to bring them back in. All right, so who's next, Mr. Mann?
Judge,
Do you want me to try to bring in this other one that's unidentified?
yes, Judge, if we could, if that is Mr. Phillips.
And you would expect that to be Mr. Phillips?
Yes, Judge. William Howell Phillips III. CR 2480.
All right, Mr. Phillips, can you see and hear us okay? I think you're still on mute, so I'll need to get you unmuted for a second.
Yes, I can hear you. Can you hear me?
Excellent. Yes, sir. We've got you now. All right, I'm going to go ahead and call your case, Mr. Phillips. This is cause number CR 24-80, State of Texas versus William Howell Phillips III. Mr. Manning, you're requesting to be put into a breakout room so you can have a conversation with Mr. Phillips. Is that correct?
That is correct, Judge.
Okay. Mr. Phillips, do you have someone there with you from the Kaufman County Detention Center?
Yes,
Okay,
sir.
good. All right, so I'm going to send a what's known as a breakout room invite, and so if the jail staff will just accept that, then it will put you in a private room with Mr. Manning to where you can have a conversation that will not be displayed here in my courtroom. Okay.
Yes, sir. Thank you very much.
You're welcome. And then once the meeting is over, you'll just remain in that room, and then I will move you back into the main session when it's the appropriate time. Okay. So
Yes, sir.
just one moment, and I will send you that invitation.
Awesome.
And Judge, I am also joining from the tablet.
Recording in progress.
And Mr. Manning, just remember, since you'll have an open loop going, you'll probably need to step out of the law library there.
Yes, Judge.
I believe that they are, let's see, they are, Kaufman County is in the breakout room. I think Mr. Manning is,
Now it's on our screen. It says Judge Martin is inviting you to join room 1.
well, it's, no, don't worry about that.
Okay.
We just need,
Did you get an invite?
we need them in room 2.
Did, but as soon as I step out there, we do internet.
Once he steps to the door, he loses internet.
Well, you may have to go up to the very front and pick up the internet up there.
Okay.
I think we have everyone else. They should be. All right. Do we have Miss Wiggins in there? Do we have Miss Wiggins?
You talking to me?
Yes, I'm talking to you. Do you have Miss Wiggins?
No, she's in Henderson County.
Oh, I'm sorry. That's right. Okay. So let's see. What about Mr. McBride? His is going to be Mr. Rodriguez. So I've got Johnson County.
That's Rodriguez.
And I don't, so I've got those two ready to go. I don't know if Henderson County has Miss Wiggins in. I've got Mr. Schmidt in here waiting. Let me see if I can get Henderson County back on, and let's see if Miss Wiggins has been moved in.
And Mr. Hernandez,
Yes,
do you have the originals that Mr. Schmidt brought over?
I actually left them. I left them for you on the desk, I thought.
Okay, those weren't signed.
Those weren't.
He told me
That-
he brought the originals to the DA's office.
check really quickly. If I may be
Good afternoon, Mr. McBride.
Morning, Judge, or good afternoon.
Is it morning where you're at? You must be on the other side of the world.
I apologize. In my brain, it is.
I tell you what, it's not hard to be a different time zone from morning to afternoon and place to place. We've got Johnson County. I think that they're getting set up here. So
Okay,
I've got them in. I think they're just getting their cameras and everything turned on, and we should have Mr. Rodriguez very shortly.
all right, very good. And I will just go ahead, since we've got a minute, and let the court know we have.
Go ahead.
We had a set of paperwork, plea paperwork signed and sent to the state, but it was not fingerprinted and it hadn't been notarized. And so I think those are the two pieces that we're missing today.
Okay. The notary, we can take care of that. I can swear him to his signature here. And then as far as fingerprint, we can send the judgment back to him and ask him to fingerprint it for us. I
Very good.
wonder why they didn't fingerprint it. Maybe because I hadn't signed it. I'm not sure.
I don't know. I've never done a plea via Zoom, so it's helpful, but I'll be honest, I was a novice at this.
Your Honor, if I may, we don't have the paperwork from Mr. McBride. I don't know how it was brought over or when it was brought over, so we're trying to track that down.
Well, I think an entirely new set was sent to Johnson County. I think Patty was working on getting a new set sent to him because they wanted the date corrected, so it would be today's date rather than, gosh, I think it was 2 weeks ago we sent it up to y'all. So I think we're getting a whole new set anyway.
So neither one of y'all has an executed set of plea papers?
The state does not, Your Honor.
I sent it to Chris Hartwell.
Was it, Mr. McBride, was it by mail or was it by email or?
Email. It was sent via email.
I may have a moment, Your Honor. Let me reach out.
Okay.
Your Honor.
Yes, ma'am.
I believe his office sent me a copy of that one also, but I've not received the corrected one with the new dates.
What was incorrect? Just the date on the judgment?
Yes, sir, because it had like 2 weeks
something.
ago.
Well, that's something that we can fix today. That doesn't need to go to Johnson County.
Okay,
The only thing that we need is if it's a corrected date, we can fix that here, Mr. McBride. You know,
Great.
we can fix that. And then fingerprints, then that's the one we really need. We can always just, I guess we can send some kind of either the judgment or a fingerprint sheet up there, email it to them, ask them to print it, fingerprint it, and either scan and send it back or mail it back to us. But I can't get them to turn on their cameras at all right now. So if we can't get past that, then
let me call them.
okay. Well, they're in. I've got them logged in, but don't want to turn it on camera.
Okay.
activity here. Mr. Rodriguez, can you see and hear us?
Yes, sir.
Oh, excellent. Okay, can you see your attorney, Mr. McBride?
Yes, sir.
Okay, we are in the process of trying to locate the paperwork that you signed a few weeks ago with Mr. McBride. So bear with us for just a second and then we'll get going, okay?
All right.
Let me know when they ask about. I was sent some more paperwork as well.
Yes, ma'am. I believe that what the attorneys have indicated is that the first paperwork had an incorrect date on that judgment that you're looking at. It had the date that he signed it versus today's date. So that probably now says, or should say, January 23rd, 2025. Right there in the top right area says the date of the judgment.
Yes.
Okay, that was one correction. And the only other thing that we were gonna ask for assistance with is on the very back page of that judgment is a place for a fingerprint. After
Yes, sir.
after the hearing today, would you oblige us in taking his fingerprint? And then we can send you a self-addressed stamped envelope or something for you to return it to us, or perhaps we might be able to scan that and email it back. But I'll have my coordinator call you before we get off. If I can get your contact information or email, then that's
Yes, sir.
really all we need is to show him that we're correcting that date and then to get his fingerprint.
Alrighty, well, let me know when y'all are ready for that, okay?
Yes, ma'am. Thank you so much.
You're welcome.
Mr. Hernandez, did you track it down?
Your Honor, that's it. It was actually sent to Ms. Taberham yesterday by Ms. Abney here in our office with all the corrections.
Okay.
So I think that's what made it out to Johnson County, and that's what they were just discussing with you.
Okay. Patty, are you there? Can you hear me?
She's not on.
Well,
Yes, Your Honor. I'm sorry.
all right. Hey, can you do me a favor? Could you just, do you have your phone with you? Can you forward that email of that paperwork to me? Oh,
Hey,
actually,
What I received from Stephanie yesterday is 3 pages. I just looked.
okay. Is it
Now,
the
I put a stack on your bench right before I came out here.
Okay, I've got that then. So
Okay.
I think the only thing that's probably updated is the judgment, and it shows the January. It shows the January 23rd date today. So I've got that. If that's the only issue, then we'll be okay. So all right, let me go ahead and call this case and we'll work through it. And if there's any issues, we'll get them corrected. All right, this for the record, this is cause number CR 18-503. This is styled State of Texas versus Josue Rodriguez. And Mr. Rodriguez, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, thank you, sir. You can lower your hand. All right, Mr. Rodriguez, this is a motion to adjudicate hearing, and you were, let's see if I can find your. Motion to adjudicate. All right, I don't have that. Give me just 1 second. I'm gonna have to pull that up. Give me just 1 second.
Mr. McBride,
Yes,
on the dates of my first arrest, which was May 31st of 2021, is that all that gonna be counted all the way to today?
I'll say this, we can talk to the jail about getting, or the clerk about getting the corrected days served, if that's the question.
Yes.
Yeah. Because it's not uncommon for occasionally they'll miss a date, and you've been
Yeah,
in
'cause-
several places.
Because it was the May 31st to December 2021, and then Navarro County, there was 10 days that they didn't add when they transferred me over to Van Zant, and the ones here, they didn't count 10 days either.
Okay, we'll talk to the folks about getting the corrected dates. That's all I can tell you. That, because nobody wants to short you on the number of days.
All right, Mr. Rodriguez. We'll take up your jail credit issues here in just a second. Let's get a little further in this. In this cause, the state filed its motion to adjudicate in August of 2024, and they have alleged in this amended motion to adjudicate what appears to be 3 allegations of violations of your community supervision. And so you had previously appeared back on April 28th of 2022. You pled guilty to the 3rd-degree felony offense of indecency with a child by exposure. The court entertained a plea agreement and followed it and did not convict you, but deferred a finding of guilt, placed you on community supervision for 5 years, and also assessed a fine of $3,500. Have you had enough time to review this motion to adjudicate?
I skimmed over it, but not read the whole thing.
Did you go over the allegations with your attorney, Mr. McBride?
Some, but I didn't get to read the paperwork. I didn't get to, physically read it.
So tell me what you did read and what you didn't read.
It was the charges that I got over here and what was it? The other
Here's the allegations,
yeah,
right?
the bottom one is what I read. The count 2.
Okay, did you not read count 1?
No.
All right, go ahead and read count 1 at this time.
Judge, if I may, it's our intention to plead not true to counts 1 and 2 and plead true to count 3. That way it leaves him available to make his defenses on the new charges.
Okay. And so here's count 3.
So that's the one. That was count 3 is not the one that I was we had talked about. Because none of this, the 3rd one wasn't on there on the paperwork. The count 2 was. Or
So count 1 appears to be a refusal to ID.
yeah, that is from Henderson County, right?
Right.
Count 2 is from Burleson and is alleging an assault,
Correct.
an aggravated assault with a deadly weapon. And then count 3 is alleging interference with emergency call.
There was to be, Judge, I'm looking at a different amended one that has he was around other people's children. And that was a technical violation that Mr. Chris Hartwell.
Well, let me do this. Let me see. There might be a second amended.
Yes. He added a count so that we could have a technical to plead true to.
All right, so here we go, Mr. Rodriguez. This is the state's second amended motion, which was filed in December of last year. And in count 3, which is a violation of condition U in your community supervision, alleges an unsupervised contact with minor children in violation of the probation conditions. Is that the correct one, Mr. McBride?
Yes, sir.
Okay, Mr. Rodriguez, have you had an opportunity to read these counts alleged in this with your attorney, Mr. McBride?
Yes, sir.
Okay, and Mr. McBride, you've answered my next question. Mr. Rodriguez intends to plead only true to count 3 and not true to counts 1 and 2. Is that correct?
That's correct, Judge.
Okay. And does your client waive the formal reading of the state's second amended motion to adjudicate?
He does.
Okay. All right, Mr. Rodriguez, I see that there is a plea agreement in your case wherein upon your plea of true to count 3 only, then the state's recommendation is that upon that plea that your guilt be adjudicated, that you be convicted of indecency with a child by exposure, a 3rd-degree felony, that the punishment be assessed at 3 years confinement in prison with the payment of the balance of money that you owe from the underlying order, which is a $2,600 fine. In addition to that, the state is agreeing to abandon count 1 and 2 on the second amended motion to adjudicate. Now, it also appears that the jail time credit, which you were questioning, what my judgment says is 435 days. Do you believe that to be incorrect?
Yes, sir.
Okay.
It's from May 31st was whenever I first got arrested that they said I had a warrant. That was May 31st of 2021. And I spent, it was 6.5 months to 7 months. And then, because I was in Henderson County, and they transferred me over to Van Zandt.
So you believe your credit is off by 6 to 7 months?
It's, for my count, it's supposed to be like 16, something like that.
16 months?
Yeah, from 21. So I did 6 or 6.5, and then 3.5 or 4, and then when I got arrested in August 8th.
All right, then, counsel, all I can do is put him back in the waiting room and let y'all talk amongst yourselves to see if you can figure out if he is entitled to that time. I'm not sure how it was calculated. So, Mr. Hernandez, you may want to speak with Ms. Adney. I don't know if there's a jail calculation sheet that she uses to help figure out how much credit time there is so that she can show what dates he does have credit for and that he can indicate what dates he believes he should have credit for. How do y'all want to handle it?
Whoever did the calculation is the person that needs to be in the room with me and with the defendant. Because he has better knowledge of it than I do.
Mr. Hernandez, do you want to consult with Ms. Abney? And then I'll just bring y'all back in the hearing in a moment.
We can do that, Your Honor. Actually, she just tendered me a list of the dates that were taken into account for the paperwork. And I have a series of dates accounting for those days that he was given credit for. The beginning date is 5/31 of 2021 through December 17th of 21. That would have been for a total of 201 days. And then there was February 10th of 24 through April 30th of 24. And that amounted to 81 days. 6/18 of 24 was 1 day. Going back, March 3rd of 23 through March 4th of 23 is 2 days, Henderson County, wherein he posted bond. And then there was August 26th, 24 through December 16th of 24 for 113 days. Johnson County time was 398 days.
And the January 29th, Navarro County, before I got transferred to Van Zandt. Because they were supposed to let me go. It was past the 10-day mark of Van Zandt picking me up, but they ended up taking me over to Van Zandt County.
Give us that date range you're questioning, Mr. Rodriguez.
January 29th.
Of which year?
Of whenever he said February, that's the date range. January 29th to the February date that he's talking about.
So you're saying January 29th prior to the February 24th date?
Yes.
Was that
We can
Navarro
double check
County.
on that, Judge.
Because Navarro County, I was in Navarro County.
If you'll just verify that, Mr. Hernandez. So is that the only time that you believe is not being
Yes, sir.
included, Mr. Rodriguez? It's from January 29th of 2000. Was that 23, Mr. Hernandez, or was
I
that?
believe it was 24, Your Honor. I've just handed the list back to Miss Abney, who's gonna go check.
Okay, so he's questioning. Okay, so she's going to go try to review that.
Yes.
Okay, all right, then I'm not sure how long that's going to take, so I'm going to go ahead and move on with my Henderson County. So, Mr. Rodriguez, I'm not going to put you in the waiting room. I'm just going to, I'm going to turn off your camera and mute you. And then
Okay.
whenever I'm ready for you to come back in, I'll prompt you to turn everything back on. So you might, I don't know if jail staff is
Yeah,
standing.
I have to go get them.
You
I
have to go
knock
get
on the
them.
door.
All right, so whenever you see me saying, turn on your camera and unmute, that means we're ready for you, okay?
Okay.
All right.
Thank you.
You bet. Just bear with us for just a moment.
Yes, Your Honor.
All right, Mr. Manning, are you ready on Mr. Phillips?
Yes, Judge.
All right, this is cause number CR 24-80, State versus William Howell Phillips the third for docket call. Go ahead, Mr. Manning.
Judge, so as you're aware, Mr. Phillips is in Kaufman County. He's pending a higher charge there. I spoke to his attorney, Mr. Guest. I believe it was yesterday, possibly the day before. He apprised me of their situation there. And the offer that I've received from Mr. Hartwell regarding this case is either we follow what Kaufman County does, or they made him a TDC offer here. After speaking to Mr. Phillips, he would like to continue and wait and see the resolution of his case in Kaufman County, as it's going to be pretty much controlling for what he gets here in Van Zandt County. In my conversation with Mr. Guest, the reset for Kaufman County is until April, I believe it was either April 14th or the 24th. And so we would request a longer reset so we can wait on the status of the Kaufman County case.
Mr. Hernandez, any opinion on that?
No, Your Honor, no objection.
All right, then the court will set Mr. Phillips for a final docket call on this case. We'll set it in April. Did you say it was April 14th, Mr. Manning?
Judge, I know it was either April 14th or 24th. I didn't write that down. I was on the phone while I was driving. So I don't have, I know it was either the 14th or the 24th.
Okay, then what we'll do is we'll set Mr. Phillips in for a final docket call on May 1st.
Yes, Judge.
That'll give him an opportunity to resolve case there. If he doesn't, then we'll move forward here.
Thank you, Judge.
All right, Mr. Phillips, we will see you in May, and I anticipate that we will have you bench warranted back to Van Zandt once you resolve your case there in Kaufman County. Okay?
Yes, Your Honor. Thank you.
You're welcome. Have a good day, sir. Tell the Kaufman County Jail staff I do appreciate their assistance.
Will
You're
do.
welcome. Have a good one.
You as well. Have a good day.
First.
All right, Mr. Manning, anyone else you're ready on?
Yes, Judge, we can call Mr. Joseph Howe.
This is cause number CR 22-26, State versus Joseph Michael Howell. Motion to revoke. Go ahead.
Judge, this is a fairly recent appointment. I'm still working on Mr. Howe's case with the state. If we could get him reset for the next available contested docket.
Any objection from the state?
No, Your Honor, thank you.
All right, court sets Mr. Howell then for motion to revoke hearing on February 20th at 1:30.
And Judge, just for purposes of Mr. Howe's credit time and rights, I show that on the docket, it shows that he has a personal bond. However, he is here in custody. If we could just confirm there is a legal hold on Mr. Howell, that way he is receiving credit for his case. Yep, sure.
Mr. Manning, I show that when the state filed this motion to adjudicate and it was signed by the court, bail was set at $25,000. Show that the capias was executed and we are set here today. So I don't show any bail being issued as far as personal bonds.
Okay.
So I'm not sure why that says that.
Well, I just want to make sure I doubted it and believed it to be unlikely, but we did have a situation recently where my client was in jail and was not receiving credit. So I just wanted to confirm that.
Yes, sir, and I'm glad you did. But yes, he's not on personal bond. He is on his bail is set at $25,000 cash or surely.
Yes, Judge. Judge, if I may, I have to talk to my remaining clients. May I have a couple minutes?
Absolutely. I'll go ahead and bring Mr. Schmidt in Henderson County.
Thank you, Judge.
Got to figure out this mute thing. Mr. Schmidt, good afternoon, sir. You see and hear me okay?
Yes, Your Honor.
All right, we're going to try to bring in Miss Wiggins. Appreciate your patience. We've had a couple of inmates, one from Henderson County and then one from Johnson County and one from Kaufman. So I've been juggling jails.
No problem. I've been watching. I understand.
Okay, good. All right, I prompted Henderson County to come on in, so let's give them just a second.
Judge, I'm gonna put some earphones in. My law partner is a little loud next door.
I can't believe that at all. Mr. Hernandez, do you
Yes,
have,
Your Honor.
do you have the original paperwork on Miss Wiggins, or does,
We do have it, Your Honor.
do you have the original? Okay.
Yes, sir. I understand it was provided to you just here momentarily, just for purposes
Yes.
of the plea.
Yes,
But
sir.
I will certainly get it over to the clerk's office, if not, maybe this afternoon, as soon as we're done.
Okay, perfect. Yes, Ms. Cassell just brought me a copy, so. All right, I've asked Ms. Taberham to call Henderson County. I'm prompting them to start, but they don't have her loaded in there yet. So Ms. Taberham is calling over there to see if we can get the jail staff to get Ms. Wiggins going. Any updates on, is Ms. Abney still working on jail time credit on the Navarro?
She is, Your Honor. In fact, it did not appear on the log at the sheriff's department, and so she's actually having to call Navarro County to verify that.
Okay. No, calculating jail credit is one of the most onerous things in part of the plea agreement, is gathering up all of that. And so I know it can be time consuming.
I don't know how I'm supposed to.
Your Honor, it has been confirmed there are 13 additional days with that Navarro County. So the total now would be 448 days total credit.
Okay, so it seems like he was questioning from January 29th up until February 24th, just because I know he's going to ask more about, well, what about those additional days? What information do you have confirmed with Navarro County? Like when do they show the hold being put on him?
They actually show the hold as of January 28th, 2024 through February 10th of 2024, 13 days.
Gotcha. Okay.
And then there's the span of time from February 10th through April 30th.
2/10/24 through April 30th.
Yes, sir. And that was 81 days on that particular stay.
Well, what about you? So I thought you had told me that it was, and maybe I wrote it down wrong, and I probably did. That's probably my mistake. So you said you originally said from 2/10/24 through April 20th of 24, 81 days.
Oh, April 30th, Your Honor.
Or April 30th. Okay.
Yes, sir.
What I wrote down was 2/24/24. So that's my mistake. That's where I was not calculating the extra 13 days. So, okay.
Yeah, the 13 days actually come in from January 28th through February 10th.
Got you. Okay. All right. We'll bring him in just a moment. I believe Miss Wiggins is getting set up right now. So we'll go ahead and take care of Mr. Schmidt and Miss Wiggins. And then we'll bring Mr. Rodriguez in. And if that appears to be correct to you, Mr. McBride and Mr. Rodriguez, then what we'll do is we'll just have the state add 435 plus 13 for the new jail time credit of 448. We'll just change that on the judgment. That'll be an easy fix.
I can change that on the judgment.
Who am I send it to?
Your Honor, Miss Abney can actually make that change. Who should she send that to?
If she wants to just email it to Miss Peggy, because she's right behind me, and
Okay.
She brought me the last one. So
Great. That's what she'll do. Thank you so much.
thank you, Stephanie. Do appreciate your help. Oh, she's, yeah, perfect. This is the one. Thank you so much. Check with Ms. Abraham again.
Hello?
Ms. Wiggins, is that you?
No, I didn't know there was another Zoom started up, honestly.
Oh, yes, ma'am. Yes, ma'am.
Because we only had one person scheduled for Zoom today.
I'm sorry. No, we were supposed to have Ms. Wiggins at 1:45 and then we
Yeah, we
already,
didn't know about that one.
okay, all right. Yeah, we already took care of
Hubbard.
Hubbard, yes.
Yes, and I thought it was done with.
Yeah, no
Yeah, we
problem.
didn't have Wiggins. Who is it? Wiggins? I mean, I can go
Yes.
get her, but it'll be a minute.
Yes, we do need her. She's actually doing a plea today.
Okay.
Her attorney's here and ready to go. We can do another case in the meantime, but yeah, if you'll go ahead and bring her in, and what I'll do is I'll just mute it, and then whenever you bring her in, I'll unmute her when we're ready.
Okay, that'll work. Let me go get her.
Thank you, ma'am.
You're welcome.
All right, Mr. Schmidt, if you'll just hang tight, hang where you're at. I'm going to bring Mr. Rodriguez back in. Mr. Rodriguez, if you can go tell the Johnson County Jail staff we're ready for them, we'll go ahead and get started on your case again. Mr. Rodriguez, seeing
Yes,
here?
sir.
Okay,
Yes,
good.
sir.
Seeing here is okay. All right, we're back on the record, cause number CR 18-503. All right, Mr. Rodriguez, when we left off, we were discussing jail time credit, and you were still in the court hearing. And did you hear the discussion that Mr. Hernandez and his legal assistant had with the court regarding an additional 13 days of credit?
Yes.
And do you believe that that to be accurate, an additional 13 days would give a total jail time credit of 448 days?
Where was the August 8th or August 8th or 9th of
Mr. Hernandez?
added on
I don't-
to?
I don't have that list before me at this time, Your Honor. It went back to Miss Abney.
Could you have her bring that back to you?
If I may have just a moment.
Yes. So Mr. Rodriguez, what they added was from January 28th all the way up to February 10th for the Navarro County time. That's all that that they mentioned. What date range are you questioning now?
August 8th, I think, when I got arrested in Henderson County and brought over here.
Was that of 24?
Yes, sir.
Henderson or August 8th, 2024 until today?
Yes. I think it was August 8th. 8 or 9. Because I asked on the tablet for my days and they have that I was arrested on the 13th. But I wasn't arrested on the 13th.
And you're talking about of August?
Uh-huh.
Okay.
Yes, sir.
All right, let's give the prosecutor a moment. He'll meet with his legal assistant and figure out what all dates he has.
Your Honor, she's going to look into Henderson County to see if there's any entries for August 10th. The only August entries I show are August 26th of 2024 through December 16th of 2024. But she said she can check to see what other entries may be through Henderson County.
And does he have credit up through today? Because we have a hold on him, correct? So he should be receiving from whenever the motion to adjudicate was filed up through today.
Yeah, I will verify that as well, Your Honor.
All right, Mr. Rodriguez, just hang tight where you're at.
Okay, thank you.
All right, Mr. Rodriguez, I'm gonna just mute you real quick, and then I'm gonna take up another case while we're waiting, okay?
Okay, thank you.
You're welcome. We'll get Miss Wiggins unmuted there.
Hello?
All right, Ms. Wiggins, can you see and hear me okay?
Yes, sir, I can.
Good. Can you see your attorney, Mr. Schmidt?
I do not.
All right, you may have to go left or right on the screen or change your view. to
Okay.
Your view. Maybe go
Okay,
to,
yeah, I see Brian now. I see him now.
yeah, go to gallery.
Hi, Brian.
Excellent. Okay. And let me check to see if Mr. Hernandez is available. I know that he's trying to assist on that other case.
Thank you.
Let's give him just a second to hop back in here. In the meantime, Ms. Wiggins, I understand that we're going to do a plea, so I'm going to go ahead and have you raise your right hand, and I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. All right, Mr. Hernandez, are you ready?
Yes, Your Honor. Thank you.
Okay. I know you're juggling a lot of plates there, so.
We're good.
All right, Ms. Wiggins, you appeared before the court previously. Look back here at your motion to adjudicate it. You appeared before the court on January 24th of 2019. You pled guilty to the second-degree felony offense of burglary of a habitation. Court heard the evidence and followed a plea agreement that day that you had met, that you agreed with the state. Punishment was assessed at 10 years confinement in prison. The court suspended that sentence and placed you on community supervision for a period of 7 years and ordered you to pay a $2,500 fine. During that period of community supervision, the state filed its amended motion to revoke your community supervision, and what they alleged violations in 8 separate counts. Have you had enough time to review that motion and those allegations with your attorney, Mr. Brian Schmidt?
Yes, sir.
Do you understand everything that you have read and signed that's part of your plea agreement today?
Yes, sir, I have.
Do you have any questions about anything before we go further?
No, sir.
Okay. All right. So, Mr. Schmidt, this is Katie Wiggins, CR 15123. All right, Mr. Schmidt, do you believe that Ms. Wiggins is competent to enter into a plea agreement today?
Yes, Your Honor.
And you've explained to her her rights as they pertain to this case?
I have, Judge.
All right. And Ms. Grisham, so all I've done was identified Ms. Wiggins and placed her under oath already. All right. And Ms. Wiggins, are you pleased with Mr. Schmidt and the work that he's done for you?
Yes, sir.
All right. I see what the plea agreement in this case is that you intend to plead true to all counts. Is that correct, Mr. Schmidt?
No, Your Honor, it's counts 1 through 7, and count 8 is being abandoned, and that is reflected in the plea agreement.
Okay. And your client does waive the formal reading of the entire motion?
We do, Your Honor.
All right. And so, Ms. Wiggins, I see the plea agreement is upon your plea of true to counts 1 through 7. The state's recommending that the court adjudicate your guilt today. Actually, I think you've already been adjudicated. What they're asking the court to do then is to revoke your community supervision and assess your punishment on the second-degree felony offense of burglary of a habitation to 3 years confinement in the Texas Department of Criminal Justice, ordering you to pay the balance of your financial obligations, which I see that you have none. You've paid off all your fines, court costs, and fees. And as part of the sentence, you would receive credit for the time that you've spent in jail. My records reflect that's 329 days of credit. Is that your understanding of the plea agreement?
Yes, sir.
Okay. All right, then, Ms. Wiggins, I would ask you at this time, how do you plead to counts 1 through 7 in the state's motion? Are those counts true or not true?
True.
And are you telling me that counts 1 through 7 are true because, in fact, what they are alleging you did is, in fact, true?
Yes.
And has anybody threatened you, forced you, or pressured you to plead true to any of the counts 1 through 7?
No, sir.
All right. Court will accept the defendant's pleas of true to counts 1 through 7. Court finds that the state has abandoned count 8. Mr. Schmidt, is there any objection to the admission of the defendant's waiver of plea of true and waiver?
No objection, Your Honor.
All right, that is admitted in evidence and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state, Mr. Hernandez?
No, Your Honor, thank you.
All right, then based on the evidence before the court finds that Katie Lynn Wiggins has violated the terms and conditions of her community supervision. Court finds counts 1 through 7 to be true. The court follows the plea agreement today. The court revokes the community supervision of Ms. Wiggins, assesses her punishment on the charge of burglary of habitation, a second-degree felony, to 3 years confinement in the Texas Department of Criminal Justice Institutional Division. Court awards Ms. Wiggins 329 days credit towards her sentence for the time that she has spent in jail on this cause. And who has the original? Do you have these originals, Joe?
Your Honor, we have the originals, and as I stated, I can walk them over to the court
Okay,
this afternoon.
Okay, that's right. I couldn't remember if we were talking about Rodriguez or if we were talking about Wiggins. So, okay. All right. So, Ms. Wiggins, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Good luck to you, ma'am.
Thank you so much.
You're welcome. You have a good day.
And you too.
Thank you, Mr.
Bye-bye.
Schmidt. Appreciate your patience. Tell the Anderson County Jail staff I appreciate their help, Ms. Wiggins.
Yes, sir, I will. Thank you.
Have a good day.
And you too.
Thank you, Judge.
Thank you, Mr. Schmidt. Appreciate your patience during
Oh,
all
no
of
problem.
this. All right.
No
Have
problem.
a good day.
You too.
All right, Mr. Hernandez, any update on Mr. Rodriguez?
Yes, Your Honor, she's actually recalculating all those dates and filling in some of those gaps that had been brought to our attention by Mr. Rodriguez.
Okay, so we need a little more time.
Actually, come in.
Judge, we're right at the jail.
Okay, we're gonna see. We may be through with Mr. Rodriguez.
We're still working with the math, Your Honor. If I may just have a few more minutes, maybe we can go on to Mr. Manning's case.
Okay, very well. We will do. All right, Mr. Manning.
Yes, Judge, ready on Miss Carter and Carter.
All right, this is cause number CR 20-204, State of Texas versus Anne Marie Carter. Motion to revoke. Go ahead, Mr. Manning.
Judge, we reached a tentative agreement with probation. We're waiting on that to be approved by the state. If we could reset Miss Carter to either the 13th or the 20th, I believe we'll be able to get her case resolved.
Okay. Will she be going back on community supervision?
Yes, Judge.
All right, then let's set her earlier if we can. Court will set Miss Carter then for February 13th at 1:30.
Thank you, Judge.
If Mr. Manning, if y'all reach an agreement and want to request a personal bond, then just notify the court and then we'll do that. If she's going back on community supervision, I'll leave that to y'all to let me know if that's appropriate.
Yes, Judge. Judge.
Yes.
Would you permit if we are able to get this, I guess, in the past, you've considered paperwork, get it signed off to be released, put back on probation. Would you consider that in this situation if we were able to get agreement from the state and able to get the paperwork filed?
Absolutely. That's what I was just mentioning. if, I said I didn't want to get between you and the state, but if you and the state and probation department agree that she's going to be placed on back on community supervision, I didn't know if there was going to be jail time as a condition. I didn't know any of those issues. So I'm saying if you, the state and the probation department all come to an agreement, then absolutely we could, you could just send the paperwork over, request a personal bond, have the state sign off on it, have probation or somebody sign off on it. That's fine too. Shoot Ms. Taberham an email saying, hey, we've all agreed. That's great. And then I will sign the order letter out and we can bring her back to court on the 13th.
Thank you, Judge.
You're welcome.
Judge, next we have Mr. Dennis.
Right. State versus James Dwayne Dennis, cause number CR 2310, CR 2496, CR 24130, CR 24131. I show that we're set for docket call. Go ahead, Mr. Mann.
Yes, Judge. This was actually, if you remember, a quick set from Tuesday. Mr. Dennis has given me some additional information to speak to Mr. Hartwell about. Unfortunately, Mr. Hartwell has been out the past 2 days, and so I was unable to speak to him regarding that. I have drafted an email with the information that Mr. Dennis provided to me in hopes that we can get this case resolved sooner rather than later. But we were unable to get his case taken care of today due to Mr. Hartwell's absence.
Okay, so what do you want to do? Do you want to reset it or do you want to put him on jury selection and see if y'all work it out in the meantime?
Judge, no, if we can keep it on docket call and just reset it to the 13th.
Okay. All right, court will reset Mr. Dennis for docket call on February 13th in all cases at 1:30.
Judge, I believe that concludes my business. May be excused.
What about Joseph Parks? I show he's bench warrant for Hunt County.
Judge, my understanding from speaking to the court coordinator is that Hunt County refused to accept the bench warrant, and he is still in Hunt County custody.
Ms. Tabraham, what was the information on that? I don't recall us talking about that.
Your Honor, I wasn't informed until just a few minutes ago when I asked transport where he was, and they said that Hunt County refused because he's headed to TDC. And that's the only information I got.
So they already had a TDC ticket for him?
I'm assuming so, but we looked him up and he is still in Hunt County. But they would not let us have him.
Okay. I'm not sure of the logistical procedure once, if he does receive a ticket, it may be that he has to be there when TDC shows up to get him, or they could be in violation of that process. I'm not sure. So I guess we'll need to let him, I guess we didn't get the bench warrant done in time before they did the ticket. So I guess we'll have to let him go to TDC, figure out where he's at, and then go pick him up later.
Okay.
Okay. All right. So let's go ahead and put Mr. Parks on a bench warrant status. We'll reset him to February 20th. Surely he'll be at TDC by then. All right, looks like Mr. Rodriguez is the only one that we have left. So, Ms. Tabraham, with that, if you want to shut down over there, I'll leave everything up here and I'll deal with, we'll deal with Mr. Rodriguez.
Thank you, Your Honor.
Thank you, ma'am.
So, Your Honor, I think your clerk may have provided you with a printout from Johnson County.
Yes, I have some kind of printout from the law enforcement center there.
And actually, the closest we could get to that August 10th date is August 13th. is what I've been told by Miss Abney. But I was also told that he may not have been on our hold during that time. So it's for that reason that a time is not being counted towards this particular offense.
Yeah, it appears that the law enforcement center there was showing an arrest date of August 26th on our Van Zandt County warrant. Let me hold this up to the camera for Mr. McBride's benefit. Let's see if I can get it up there. Tell me if that focus is in okay.
Yeah, that's great. Thank you. That's great. Thank you. I took a screenshot of it.
Okay, good. Can you see that, Mr. Rodriguez? Sure, I'm sorry. Can't tell where I'm putting this thing.
It works there, Your Honor. He's muted, unfortunately, so we can't hear.
We got to unmute you there, Mr. Rodriguez. We'll let him go. All right, sorry about that, Mr. Rodriguez. I'm gonna put this back up there. Tell me, can you see that there?
Move it up a little bit.
This way?
Yes. Can you move up a little bit? I can only see my. Okay. Up a little bit more. 826.
That's what the law enforcement center there in Johnson County is showing when they put the hold, when they executed the Van Zandt County hold. Shows your arrest date is August 13th, and then that they placed the hold for August 26th.
Because the same date that they arraigned me here, they did this one too.
Yeah,
That's why I was asking. That's why I sent a request on the tablet to ask how many days I was here. And they said from the 13th of August, which I was arrested on the 8th.
Yeah.
In Henderson County.
Well, this is this is Johnson County.
Johnson County.
Yeah, this is what we got from Johnson County. What did you get from Henderson County?
It was August 8th. I was arrested on August 8th.
Mr. Hernandez, do you have anything else from Henderson County? I think she said that she was working on that.
I do have the Henderson County entries, Your Honor, but the issuing authority for those particular arrests were from Burleson PD. I don't know if maybe that's going to help there.
I can't see that.
Yeah, a little blurry. Back that out a little bit. Let's see if it'll focus. Maybe in a little bit.
I'm not able to see that.
Yeah, it's still kind of blurry. Can it maybe come towards the camera a little bit? A little more. Yeah, it's not focusing.
I can barely make it out.
Yeah.
3.
Not really.
So those dates. So those dates wouldn't count. Is that what y'all saying?
Yes, sir. And that's the book date of 8/8 of 2024.
In Henderson County?
Yes, through Henderson County, Burleson PD.
So Henderson County booked him in on Burleson PD's charge.
Yes, sir.
Before. Okay.
Yes, sir.
All right. So tell Mr. Rodriguez how many days it is total now that you are indicating that you've been able to confirm for his jail time credit.
So the confirmed total is 448 days. And there was a clarification on August 26th of 2024 through yesterday's date, 1/22 of 2025 for a total of 150 days.
That's included in the 448.
Yes, sir.
Okay. Mr. Rodriguez, do you need to talk to Mr. McBride about that?
Yes, because we had actually talked about, I had mentioned it to him about it. But he said he was gonna check, but I never got back to him because Mr. Steele, I think, came to talk to me.
Okay, well, this is what the prosecution office has been able to confirm with not only Van Zant law enforcement, but also Johnson County and also Henderson County. So that's the credit time that they are indicating that you are due. So that's what they would be recommending to the court today. We can reset this hearing and come back another day and y'all can try to get more evidence or proof of that and submit it, to the DA's office here and compel them to show that there's more time, or we go forward today with 448. Do you want to talk to Mr. McBride privately for a second?
Yes, sir.
All right, so Mr. McBride, let me put you all in a breakout room. Mr. Rodriguez, you'll need to have the jail staff move you into a breakout room. I'll send you an invitation.
Okay.
Thank you, Judge.
You're welcome. Give me just a second.
Now.
Just accept these invitations when you get them.
Okay. Now. No, they need to put me in a room, breakout room. Y'all need to put me in a breakout room, with the judge. Yes, on. Talk to my attorney. She had it last.
Okay, what do we need to click on?
You should have received an invitation to join a breakout room. Do you see that? It says join breakout room. About right now.
Here we go.
Just join that and then he'll need to move back later. And as I'm going to sign some documents, but I won't be going anywhere. We'll wait for them.
All right, sir. I'll do the same thing, sign off, but I'll still be here. Thank you.
Ah,
Mr. McBride,
yes,
have we had any kind of resolution on jail credit?
yes, I believe he and I have talked it through and we are in agreement. We'll have to probably rejoin him. I have to call in again because I'm a little tech
I'm here, I think.
unsavvy.
Yeah, he's here. I see him.
Okay, okay, very good. So yes, I think we're fine with the 448 days credit.
Okay. All right, Mr. Rodriguez, you agree?
Yes, sir.
Okay, all right, then let me pick back up where I was. I'm glad that you brought that to our attention so that we could get those extra days in there for you. All right, so let me go back over the plea agreement again, just because it's been a minute and I want to make sure that I'm thorough. So this would be a plea agreement on a judgment adjudicating your guilt. You're pleading true to count 3 and count 3 alone of the state's amended or second amended motion. And the agreement is upon the plea of true to count 3 and the second amended motion. The recommendation is that your probation be revoked, that punishment be assessed at 3 years confinement in prison, with you paying the remainder of your fine, which is $2,600, and you would receive jail time credit of 448 days. So if that is everyone's understanding, then at this time, I will ask you, Mr. Rodriguez, how do you plead to count 3 in the state's second amended motion to adjudicate? Is that allegation in count 3 true or not true?
True.
And Mr. Rodriguez, has anybody threatened, forced, or pressured you to plead true to count 3?
No.
All right, then court accepts the defendant's plea of true as to count 3. Mr. McBride, is there any objection to the admission of the defendant's waiver of rights and plea of true into evidence?
No, sir.
All right, that is admitted, and the court does take judicial notice of the defendant's judicial confession. Further, the court does find that the state has abandoned counts 1 and 2 on the second amended motion as part of this plea agreement. Is there anything further from the state, Mr. Hernandez?
No, Your Honor, thank you.
Is there anything further from the defense?
No, Your Honor. Thank you very much.
Okay. Then, based on the evidence before the court finds that Josue Rodriguez has violated the terms and conditions of his community supervision. Court finds the allegation in count 3 to be true. The court revokes his community supervision, assesses punishment in accordance with the plea agreement at 3 years confinement in the Texas Department of Criminal Justice. The court orders him to pay the remainder of his financial obligations. Further, the court awards him jail time credit of 448 days. So, Mr. Rodriguez, you will be remanded to the custody of the sheriff so it can carry out the terms and conditions of the sentence handed down by the court today. And so what I will ask you to do, if you will ask jail staff to come in again, then what we'll do, I believe Mr. Hernandez, I don't know, let me see if I have the corrected judgment for Ms. Wiggins. Do you know if Ms. Abney has sent over a corrected judgment of 448 days yet for Mr. Rodriguez?
My understanding was that it had been sent over, Your Honor, but I could certainly confirm that.
Yeah, if you don't mind. I've got, oh yes, I do. I do have one. I see it here. So we're on the left side. All right, so Mr. Rodriguez, if you'll step out and get jail staff to come in, then what I'm going to do is we're going to email them a copy of your judgment, and then I'm going to ask that they take your fingerprint on the back page there.
Okay.
All right.
Is that the one they had, the same one they had, or?
I'm not sure. We need to make sure that they have the updated credit. If look on this judgment right here, look down here on the lower left and make sure it says 448. If it doesn't say 448, then we'll send you another one that says 448. But all I need is your fingerprint right there on that square. Okay.
Okay. The judge is asking for you. For the paperwork.
Mr. Rodriguez, I apologize, my mind's still foggy. So have we located where the original paperwork is on Mr. Rodriguez, the signed copy that he said that he sent to Mr. Hardwell by email? Have you been able to lay your hands on that has Mr. Rodriguez's signatures?
No, Your Honor, but my understanding was that those were incorrect and they needed to be corrected.
Well, my understanding was the only thing that was incorrect was this judgment page, that everything else would be fine. That the plea agreement page, the trial court certificate, the Brady, all of that's good. The only corrections would need to be made is what we've made today.
Yeah, no, I don't think we have. That's why I was asking Mr. McBride when those were sent over. I'm not sure he gave a clear answer to that, if it was last week, because obviously the ones that were sent out 2 weeks ago, we did not have.
Do you know when you emailed Mr. McBride? Do you know when you emailed Mr. Hartwell?
I think I was going to look that up, and then your assistant got on and said she was the one that received them. So I think they went rather than to the state, they went to the assistant. So I think if we could ask her, I believe she's got it. I don't know if that was Patty.
Yeah, all Patty received was the judgment. She doesn't have all of the remainder of the plea.
Can you name another staff person other than her? I don't remember who else I might have sent it to.
Ms. Abney, Ms. Stephanie Abney at the DA's office, maybe? ABNEY. Do you still have them with you, Mr. McBride, that you could just scan them now and send them?
Yes, here they are. They went to her on 12/9.
To Ms. Abney?
I believe so.
Your Honor, she's just sent me a set of paperwork that has been signed.
Yeah, so saving except for the judgment, which we've corrected today for date and jail credit, we just need all of the other documents that have the signature on it.
Sir, I'll print these out and get them over to the clerk's office this afternoon as well.
Excellent, great, thank you. Mr. Rodriguez, is jail staff in there yet, or are they still on their way?
Yeah, they're here, but on this one, it says 5 years and 435 days.
Okay, I'll tell you what, all right, who's in there with you? Man, what's your name?
Officer Islis.
Officer what?
Islis.
Okay, I'm gonna send you a message here on Zoom.
Okay.
Did you receive that?
Yes.
Okay, can you just send me a message back, your email? I don't want you to say it because we're on YouTube. And so I want you to can you just type in the email address that I can email this new updated judgment, which will say 3 years and 448 days. And then I'll have signed that. And all I need to do is get you to fingerprint Mr. Rodriguez. And then I will have an email address. I'll message you an email address to send them back to.
Okay, let me go get the keyboard and mouse real quick.
I'll send it to you.
I'm gonna go grab the paperwork, Your Honor. I just printed it out to make sure I have it, and it'll
Thank
get
you.
over to your office this afternoon.
Thank you.
Yeah, she's gonna walk out with this too.
Alrighty, let me give you, I'm gonna give you an email address here. If you'll go scan this. This email address.
So did you want me to still have him fingerprint this copy that I have and the other one, or?
No, ma'am, just the new one that I'm gonna send you. It's gonna be updated with dates and stuff like that. So I'm writing out your email address for my legal assistant, and she's gonna go and scan it to you right now. All right.
Okay.
So the new one will come. It'll say 3 years. We'll have today's date, 3 years, 448 days. You'll just fingerprinting and scan that back to Patty, who will be emailing it to you.
Okay, I'll be right back.
All right, Mr. McBride, I think that we've got everything taken care of. We'll wait for Mr. Hernandez to get back to make sure that we've got all the plea papers. Other than that, I think that'll be good.
All right, thank you so much. And I want you, if you don't mind, pass along, thank you for doing all this, and your patience is incredible. Putting up with all the back and forth, and then also thank your staff and the state, because it really, this is the first time I've done a Zoom plea, and it just wasn't, I didn't know what I should be doing or not. So anyway, thanks to everybody for getting this done.
Absolutely. Well, I understand it's not as smooth as when you come to court, but it also saves our detention officers from having to drive, an hour and a half one way to pick you up, do the cost and all those things. So I know it takes a little bit longer, but yeah, I think it saves us time, and it'll only get smoother. We're actually going through the process of having digital plea papers done. So in the future, if we do it, it'll be by email, it'll be on a tablet, should be a lot cleaner and smoother and that. So yeah, you're welcome on that, but we are trying to make things a little more efficient with digital technology. So
very good. Thank you. May I be excused?
yes, you're excused, Mr. Rodriguez. You're excused as well. The detention staff is going to just take your fingerprint. They're going to email it back over here, and it's going to be a part of your papers, and you'll be done. Okay.
Okay.
All right. Thanks, sir. You have a good day.
Thank you. You too.
Thank you.
You're welcome.
Your Honor, I accidentally printed out Mr. Rodriguez's paperwork out to the clerk's office printer. I thought that I had switched, so Miss Elizabeth has them.
Oh,
I was
excellent.
going to bring them out to you if you need that, but
Well, that was a smart mistake you did, because now you don't have to print and drive and do all that. You were just
I still have the Wiggins paperwork to get to you, so no problem, no worries whatsoever.
All right. I appreciate it.
All right, sir.
If that's it, then I think we are adjourned for the criminal docket. You all have a good day.
Thank you very much. Bye-bye.